We have a smaller crew today. I'm hoping that more will join. There was a handful of folks in our community that were on a city commission meeting until the wee hours. And then Carrie, how about you let me know? I see we're recording.
Let me just get us to.
Welcome,
Might
Phil.
take me just a minute, so let me.
Hi, Joe. We're getting more folks.
Hey, Michelle.
Well.
How you doing?
Doing well. Nice to see you.
Oops, I'm stuck.
Did you get my
Michelle,
message about our May 27 call?
Yeah, I'll follow up with you. We gotta.
But I mean, you got my second message when I said we're good to go.
Yes, thank you.
Because I okay, good. I didn't want you to rearrange it now that I've rearranged my meeting.
All right, looks like we're getting. Hi, Pete. Hi, Andrew.
Michelle, if you can let some folks in, I'm working on the Facebook Live.
Okay. Yeah, we got quite a few folks coming.
I'm trying to get us onto PCEC.
You know, and I can go ahead and kick us off while you're doing that. I think Jenny's part is, oh, it looks like we're streaming, so we're good to go.
I just want to make sure we're streaming on PCEC. So, but go for it. Well, I'll work it out.
Thank you. Okay, we're gonna get started, and we are thrilled to have this presentation today with Livingston local and Earthjustice attorney Jenny Harbine joining us to discuss our landmark legal victory in PCEC versus DEQ. You know, this happened in December, right before Christmas time, and it was sure a joyous and momentous moment. And we haven't really fully celebrated, so I'm excited to discuss today, and I think we should continue to plan to celebrate in a more fun way as well sometime. So as always, these presentations are recorded and we'll share them on our website. So if you miss it or if you have somebody else that might be interested, you can find them at pcecmt.org/community conversations. And before we kick it off, I'm going to do a quick introduction. So I think most of you know me. I'm Michelle Ubaraga, and I have the pleasure of serving as Park County Environmental Council's Executive Director. We are your local grassroots conservation group. We work here in Park County with people to protect the land, wildlife, waters in Park County, and we do that through grassroots advocacy and organizing. Park County is the traditional homeland of the Apsaloka, or the Crow tribe, and their ancestors for the Crow and other indigenous people across the region, like Northern Yellowstone's Tukadika. This area is continues to be culturally and spiritually significant and home. Park County has a long tradition of human habitation, of people who have loved, cherished, and stewarded this place, and we are committed to working together in honor of that legacy and this place for future generations. All right, so I'm going to skip over. We've been hosting these conversations. We're so excited to share with you about this legal win. I'm going to give a quick background. Our community started organizing in opposition to two gold mines in 2015. After years and combined community effort, we passed the Yellowstone Gateway Protection Act, protecting public lands, 30,000 acres in 2019. Meanwhile, both companies were continuing to pursue permits on private lands. And so that's where our litigation comes in here. Lucky Minerals was granted a permit to begin exploratory drilling in Emigrant Gulch, and that's at the heart of the issue here. We are also joined by PCEC's Carrie Kale, who I will introduce after Jenny's presentation, to talk about you know, not only Emigrant Gulch, but what's still happening. And there's a proposed, still some stuff going down in Jardine around Crevice Mountain. So we hope to reserve about 20 or 30 minutes for questions and conversations. But first, I'm going to pass it over to Jenny to talk about PCEC versus DEQ. Take it away, Jenny.
Thank you. Just at the outset, I use she, her pronouns. As Michelle said, my name is Jenny Harbine. I'm a staff attorney with Earthjustice. And I thought today I'd start with a brief background about Earthjustice. I see some names here that are kind of new. And then I want to talk about the issue of proposed mining in Immigrant Gulch and our legal strategy, which culminated, as Michelle said, in a Montana Supreme Court decision last December. And then to finish up, I hope we can engage in a conversation about the implications of the litigation and what it means for our future strategies and challenges. I'm going to share some slides here, not because they convey a lot of information, but because I've noticed that like the headshots get smaller when you show your slideshow. So I hope y'all can see my screen here. First, about Earthjustice, we're a law firm for the environment. We have 14 offices across the country and 150 lawyers across the country. I'm housed, although I live in Livingston, thankfully, my office is in Bozeman, Montana, where we have a staff of 7 folks, including 5 lawyers. And we represent clients in federal and state courts and in administrative proceedings in Montana and across the Northern Rockies. Earthjustice is a nonprofit that's founded on the belief that law is a powerful tool for change. The courts are a forum where facts matter and where we can go toe-to-toe with well-funded industry and government lawyers and parties, and we can win. But in our theory of change, we don't achieve change, at least not meaningful and lasting change, just by filing and winning lawsuits. We use our litigation to tell the stories that matter about the resources at stake, and we give power to the stakeholders that can galvanize a movement. So inherent in our business model as lawyers and in our theory of change is the importance of partnership. And we've been so lucky on this issue to be able to partner with Park County Environmental Council, as well as with Greater Yellowstone Coalition, National Parks Conservation Association, and the many Park County business owners and community members who went to bat to protect this place. This is Immigrant Gulch. In 2015, Lucky Minerals proposed extensive exploration for gold and other minerals in Immigrant Gulch. And I'm guessing everyone in this virtual room is familiar with this landscape. Chico Hot Springs sits at the mouth of Immigrant Gulch, which is flanked by the Absaroka Mountains, including Immigrant Peak. Lucky's initial exploration proposal involved drilling both on patented mining claims and on adjacent forest lands. And a patented mining claim is just, land that used to be public land was brought into private ownership through the process authorized by the 1872 mining law. And so those patented mining claims now are considered private land. But in this initial exploration proposal, Lucky's plans span both private lands and public lands. And in fact, we learned about the proposal in 2015 when the US Forest Service issued a notice saying that it would plan to consider and approve Lucky's proposal for public lands drilling using a tool under the National Environmental Policy Act called a categorical exemption. Now, this notice of the first phase exploration proposal was daunting enough, but our friends at Greater Yellowstone Coalition, and I see Joe Josephson is on this call, so shout out to Joe for doing some really good research on this issue. Tracked down a technical report that Lucky Minerals filed to comply with financial disclosure obligations in Canada. And this technical report gave rise to even more concerns. We learned that, in fact, this first phase of the proposal was only a minuscule part of the company's overall plans for Immigrant Gulch, which is to produce a multi-million ounce gold mining operation. And we learned that it spanned a really alarmingly expansive landscape over this terrain. And so PCEC and GYC and others jumped into action to educate the community and galvanize the community against this proposal. They held community meetings in the summer of 2015 in the communities of Gardner and Emigrant and in Livingston, and many of you probably attended those meetings, but they were led by Michelle and Joe. They brought in mining experts, they brought in economic experts and legal experts just to educate the community about what this proposal would mean. And they generated thousands of comments on the Forest Service's plan to rely on this categorical exemption from NEPA to approve the project. And as a result, the Forest Service said, you know, Uncle, you're right. We can't take this foreshortened approach to evaluating what could be a really massive project. So lucky if you want to come back with another proposal, we're going to have to do a more fulsome review under the National Environmental Policy Act for this project. And as a result of the Forest Service's changed course, Lucky Minerals changed its tack too, saying that it would focus its initial exploration on just private lands. This took the federal government out of the process and really focused all the attention on the Department of Environmental Quality at the state level to review and approve the project and put the onus on the Park County community to give DEQ the goods to stop it. This private lands exploration proposal included a plan to drill 46 exploratory drill holes, each up to 2,000 feet deep. On private lands, as I said, that were patented under the 1872 Mining Act. So this coalition, including PCEC, GYC, Earthjustice, National Parks Conservation Association, and the newly formed Yellowstone Gateway Business Coalition, focused now on a two-pronged strategy because the public lands were no longer at issue in this initial exploration proposal. We had a long-term strategy to protect those lands. And then the more immediate concern, or not the more immediate concern, but the separate concern of drilling on private lands required a different strategy. For the public lands part of the strategy, we set our sights on a withdrawal of minerals from mining. That's its own very long, very inspiring story. And the real heroes of that story are the members of the Yellowstone Gateway Business Coalition. I see Andrew Field on this call. Thank you, Andrew, for your important role in that. This, of course, is Brian Wells. I don't think it's a spoiler to anyone on this call to say that that story ended with a tremendous victory in March of 2019 when Congress declared 30,000 acres of public lands in the Custer-Gallatin National Forest, including Immigrant Gulch, off limits to mining. But that amazing victory, unfortunately, did not address mining on private lands, which itself could have devastating impacts on the landscape and water quality of this treasured landscape. So DEQ continued to evaluate that private lands exploration proposal under the Montana Environmental Policy Act, or MEPA. And in the fall of 2016, DEQ issued what's called an environmental assessment. And if you're familiar with NEPA, you'll know that an environmental assessment or an EA is the shorter form of environmental review allowed under MIPA. And if your EA shows that a project won't have any significant impacts, you can stop there. Otherwise, you have to do a more rigorous review in what's called an environmental impact statement. So PCEC and GYC continue to have public meetings regarding this MIPA process that was underway, and invited, in fact, representatives from DEQ to speak at these meetings, and again, invited economic experts, legal experts, mining experts, and again, hundreds of Park County residents turned out at the meeting. This picture is not from a wedding, but one of our public meetings at the Elks Lodge here in Livingston. And again, thanks to the just tremendous engagement of this community, thousands of public comments were submitted on DEQ's environmental analysis. Nonetheless, as Michelle said, in the summer of 2017, so 2 years after we first learned about the project, DEQ made a final decision to grant the exploration license. And it did so based on this environmental assessment. It never prepared an environmental impact statement, despite the public comments on the really potentially significant harmful impacts that the proposal would have. So PCEC and GYC, represented by Earthjustice, went to court. And we went to court here in Park County in our Livingston courtroom. And sorry, I don't have my thumbnail slides in front of me, so I don't know exactly where I'm headed until I go there. But our legal strategy involved two stages. The first stage was to convince the court that DEQ's environmental review didn't comply with MIPA. And MIPA requires agencies to undertake a rational evaluation of all of the environmental impacts of a project. And we submitted hundreds of pages of comments and attachments with technical information about the potential environmental harm from this project. And the district court agreed with us in an opinion that Judge Gilbert issued in May of 2018 that DEQ hadn't taken a rational view of all those impacts. And that included the impacts that the road improvements would have on wildlife. According to Fish, Wildlife, and Parks, those impacts would be potentially long-term because it would give access by hunters, et cetera, to this area that could cause conflicts with wildlife such as grizzly bears and imperiled wolverines. In addition, the court agreed with us that there was a potential for harm to water quality and other resources from the exploration project. But this was only the first stage of that litigation in the district court. As a second stage, we had to convince the court to do something about this violation. And this is actually a trickier issue because in 2011, our legislature had amended the Montana Environmental Policy Act to say that even after a court finds that there's been a MIPA violation, all the court can do is basically tell the agency to do more paperwork. This is called a remand to the agency, and the agency, DEQ in this case, would say, okay, we'll redo our environmental analysis and try to get it right, and our second bite at the apple. But what the court can't do is stop the project or revoke the permit for the project. And so, this leaves us in the really absurd situation where Lucky could cause all of the environmental harm through the road improvements, through the drilling, and water quality harm, while DEQ was studying that very harm. It really flips MIPA on its head. We think of MIPA as a look before you leap statute, meaning that agencies have to consider all the environmental harm before they make a decision to authorize that harm. And in our view, these amendments to MIPA converted that statute into a leap before you look enterprise, where the agency would approve this exploration project, it could go forward. And then even as DEQ is back to the drawing board, evaluating whether the environmental harm is too significant, whether there are ways to maybe mitigate or lessen the harm through changes to the project and mitigation measures. Even as DEQ is doing that, the project could go forward. We argued that these provisions were unconstitutional. Now I'll get into that claim a little more deeply as we go forward. But in April of 2019, the district court agreed with us and said, yes, we think that these remedial restrictions that the legislature enacted in 2011 are unconstitutional. And as a result, we are going to, or the court invalidated the exploration license so that the project couldn't go forward at that point. Now, lucky DEQ and the Attorney General, which had intervened to defend the constitutional claims, appealed that decision to the Montana Supreme Court. And in December of 2020, the court issued a ruling that finally resolved this legal dispute. I guess this gives you an idea of how long these things can take. When the project was authorized in 2017, and it took nearly 3 years to get a final resolution from the Supreme Court. And I note that time frame just because it highlights to me how important it is to be able to get that remedy from the district court, to be able to stop a project while the process runs its course. And I think it's important to remember that stopping the process it doesn't need to mean that the project ends at that point, right? They can go back, satisfy their legal obligations, and continue. So this isn't a case where you're saying, no way, no how can you do what you want to do on private lands. It's just saying you have to follow the law when you do that. On the MIPA issues, so this was the first stage of the project I mentioned, DEQ actually conceded the illegality of its analysis on certain issues, importantly that road improvement issue that I mentioned, as well as the question of whether they had required adequate measures to mitigate the water quality harms from the project. The court disagreed with us on certain other issues, including that DEQ's alternatives analysis, the court found complied with the law, and that DEQ didn't have to study the environmental impacts of full-scale mining. It could really narrowly focus its review just on the exploration project. But because the court and DEQ, for that matter, agreed with the district court that certain aspects of its environmental analysis were inadequate, it had to go to the next phase and consider the remedy. And there the court again agreed with the district court, and this is really the extraordinary part of the Supreme Court's decision. It affirmed the district court's order vacating Lucky's exploration license and found that those 2011 amendments to MIPA were unconstitutional. And the constitutional claim boils down to two provisions in Montana's constitution. The first gives Montanans the fundamental right to a clean and healthful environment. And the second says that Montana's legislature has to provide environmental remedies, to allow people to vindicate that right, basically. So these two parts of the Constitution really work together to give us, what the Montana Supreme Court has called anticipatory and preventative measures to avoid unreasonable environmental harm. And before I look at the specific holdings of the Montana Supreme Court, I want to highlight this provision from the court's remedy ruling, where it said, it talked about the agency's MIPA violations here, which is really a failure to analyze and provide information about these environmental consequences of the project. The court said, this information gap occurred within the greater Yellowstone ecosystem and the Yellowstone River watershed in an area a mere 15 miles from the national park, home to important wildlife, habitat for wildlife, popular for recreation, and in a tourism-dependent human economy. And the reason I want to note that is because it goes back really to the theory of change I was talking about earlier. These words aren't really important to the legal decision that the court reached. What they do is they create the backdrop for that decision. They bring to life for the court and to readers of the court's opinion what's at stake. And I think here that backdrop was really important in achieving the result that we achieved. The court, looked at the role of the Montana Environmental Policy Act in, letting Montanans vindicate their environmental rights. And they say MIPA is unique because it requires agencies to be informed when they make decisions. And although that's just procedural, it doesn't, drive any substantive outcome. The court takes the uncynical view that informed decision-making is better decision-making. And then second, if you don't have a mechanism to prevent environmental harm while that decision-making process is happening, then it obliterates the Constitution's anticipatory and preventative constitutional obligations. I could actually quote from every paragraph in the court's opinion because it was so remarkable. But I thought this was another good one. MIPA is an essential aspect of the state's efforts to meet its constitutional obligations, as are the equitable remedies without which MIPA is rendered meaningless. And when the court says equitable remedies, they mean they're the ability for the court to stop a project, to enjoin a project, to invalidate a license. And they say MIPA doesn't mean anything if you don't have the ability to prevent that environmental harm while MIPA serves its purpose. And the court placed MIPA firmly at the center of avoiding environmental harm. Talking about the role of MIPA in minimizing the risk that an agency will make an irreversible mistake only to regret it later. And I think this is kind of an esoteric concept, but it's really best visualized through our experience here in Park County. Sometimes these environmental review laws like MIPA and like NEPA are called people's laws because they give folks like PCEC and its members the opportunity to really participate in the actions of state government, to make their voices heard in a formal way. And one of the important parts of MIPA is that it requires an agency to actually respond to those comments. They can't just blow you off. When you submit a comment under MIPA, it doesn't go into a black hole. It's supposed to go into a formal record and inform DEQ's decision making. And that's the role that MIPA plays and that the court affirmed in this decision. And the decision is going to have an impact on future issues. It really breathed life back into this constitutional provision that itself is remarkable, but through the court's animating text, it really gives life to and meaning to these words that we have an inalienable right to a clean and healthful environment. And so I expect this to be one of those cases that is cited for years to come in court decisions and in literature about what our Constitution gives to us. And I'm so proud that that decision says Park County Environmental Council. That should not have made me cry, but something always does. So that's what it is. So proud that PCEC's name is on this court decision. And I'm so proud of this community for taking the stand it did to stop this project and achieve this really extraordinary result for the state of Montana. And that's all I have.
Thank you, Carrie, or Jenny. Thank you. I'm going to introduce Carrie now as well. That was wonderful. And as always, much appreciated. You make me get emotional as well. It's good to be proud of our community and this place and the hard work that we've all done together. So yeah, it is truly a landmark victory that will have implications for a very long time. And it's something that we're incredibly proud of, and we could not have accomplished without you and your help. So thank you. From the very beginning, you know, Jenny, as I think many of you know, Jenny not only was our attorney, she's a community member. She served on PCEC's board. She was a strategic mind, helping us guide our campaign from the start to finish. So a really important ally. Thank you. And then Carrie, also another really important ally on this effort. So I asked Carrie to give a quick update on kind of what's happening now. And so many of you know Carrie Kale, who got involved also right at the beginning of this campaign, rolled up her sleeves. I think Carrie single-handedly signed on the first 100 businesses, going door to door as a volunteer, an employee of Chico. And Carrie just gave countless hours of her time volunteering to help get this campaign up and off the ground. She eventually came on and served as the community director for the Yellowstone Gateway Business Coalition. I sometimes call Carrie our grassroots ninja. She kept us all organized, led meetings, pulled people together, made sure everybody had what they needed to testify and knew. I mean, Carrie is juggling and planning and was really continuing to move us all along gracefully. So thank you, Carrie, for your leadership. And then we got to invite Carrie to join PCEC staff this year. And so PCEC is now, or Carrie is now our, I can't even remember your title, business.
Let's see, I am the Business and Community Partnerships Director for Park County Environmental Council. So
yeah, so Carrie will continue. I mean, I think that we saw the power of businesses in our community to affect change, to work together, and we wanted to be able to continue to do that work with all of you. And so Carrie is leading that effort now for PCEC and all the other places where we'll continue to need more advocacy. And there's still ongoing work in the mine campaign. So I'll let you give a quick update on that, and then we should have probably 20 minutes for questions and conversation.
Perfect. Thanks, Michelle. And I have just something, a really brief sort of update. So we as a coalition of partners continue the situation on the ground in both Immigrant Gulch and Crevice Mountain. And that includes PCEC and Bear Creek Council and the Greater Yellowstone Coalition and Earthjustice and NPCA. We continue to keep an eye on what's happening. While there's currently no current activity happening, on the ground. So no trucks on the road, you know, nobody drilling a hole at this point. We do know that the Crevice Mining Group continues to file yearly to obtain their small miners exemption permit. It's the same permit that they have been filing for since 2016, and we do know that they filed for that this year as well. We continue to assume that at some point the Crevice Mining Group will move forward with planning to mine up in Jardine. So that's up in Crevice Mountain. And so we know that that is a potential. We keep watching to see if Lucky is doing anything. Obviously, nothing's happening with Lucky at this moment. I think we all know that we may all need to look to you know, defend our victories as we move through time. And we keep looking for tools that might help us mitigate some of those industrial operations that show up in our community. One tool that's sort of rising to the top that we at PCEC are keeping our eye on is a conflict mitigation zoning district. The Park County Planning Board is currently working on a proposal that could be helpful to mitigate these sorts of industrial operations across the county. And so to learn more about that, you can find a copy of that draft proposal on the county website if you'd like to take a look. The County Planning Board does have regular meetings. They have one this Thursday at 4 o'clock. So if you'd like to tune into that, if you go to the county website, you can find the link to zoom into that meeting as well and hear a little bit more about that. I know that we at Park County Environmental Council are also planning to do some additional educational events around conflict mitigation. So stay tuned and we will get that out to folks as those opportunities come along. So that's just a brief update of what's happening on the ground.
Thank you, Carrie. And so I want to invite folks to go ahead and put questions in the chat. And then I also know we've got Joe Josephson from the Greater Yellowstone Coalition, who you all know was a critical, powerful ally and teammate. And so Joe, I welcome you if you want to join in on the conversation. So feel free to put questions in the chat or to just go ahead and turn your video on and unmute if you have questions. And if we don't have questions, I have some. Oh, there's Jeff. Jeff's, yeah, go ahead, Jeff.
Hey, thanks, Michelle, Jenny, Carrie, Michelle, Joe, who am I missing? Others on here. Thank you for your passion and efforts on this. It's good to see it being fought out in the courts because the fights that happen in the local sphere are continuing. So it's good to see that there's some level of precedent that will hopefully drive civil conversation around the topic. I'm wondering, here's a question, and it's primarily directed at people who aren't part of an agency or nonprofit, a few of them on the call. And as full disclosure, you know, some of these I know the answer to, so I'm not trying to like stir the pot or anything, but the Business Coalition effectively doesn't exist anymore as like an organized group that is actively meeting and soliciting members and whatnot. There are other groups that do that really well. But with the new administration and you know, things like John S. bill taking away local county planning capabilities and almost to a certain extent putting it at a state level or just dismantling it altogether. And it feels like, I can't prove it, it feels like there's a little bit more of a target on organizations like Earthjustice and even PCEC and GYC that aren't tied to business or directly to private landowners. So those two trends happening today as we speak with the legislative session that just finished and various bills that were passed seems like it's going to make conflict mitigation almost dead in the waters. And so that was a long way to get to kind of for you, Jenny, what existing laws, including, this ruling, can be used that's still left over for locals to argue for certain protections that the Constitution has. I'll give one example. There's always been an agricultural rule that Park County, that any planning board could use to deny a permit based on impacts to agriculture. And yet it has never been implemented in Park County once, ever in its history. And yet, I could run through examples of, knapweed spreading because of certain developments that started and stopped. And, no real meaningful muscle to enforce clean water or invasive weed spreading. So I'm not hopeful personally with the trend that's happening. And then I'm not hopeful that even existing laws are used at a local level to do anything meaningful. This was a big effort, right? Huge effort, ta-da, but there's still constant pressure at a local level. So in your advice, what's standing that we can use to bring up with our legislators and one another to help maybe have civil discourse about what's acceptable development? And that's, Jenny, go ahead. Give us one thing, maybe.
I can try to help too. You go, Jenny, and I'll see if I can help.
Yeah.
Yeah, thanks for the slow pitch, Jeff. And I mentioned Andrew's role in the Business Coalition. I didn't see your name, Jeff, before I popped on my presentation. So thank you for your really important participation in this effort. It's no joke that the legislature came after us in this last session. And I think many of those efforts, frankly, are quite cynical. For example, one of the pieces of legislation that passed related to the venue for legal challenges such as this. MIPA's always had a venue provision that since 2003, I think, has had a venue provision requiring these challenges, be brought in the courts that, reside in the counties where a facility or a project is located. And there is new legislation that requires, similar local venue for all sorts of different challenges. And it was sponsored by a legislator who we're often up against, who represents in court industrial interests primarily. And, I just cynical to think that, every local court is going to side with, a proposed industrial activity. And I think, again, our case shows that with, the groundwork to show the community support for your position, that, first, the court shouldn't be influenced by local politics, but second, to the extent that we, can see that as an atmospheric pressure point on a court's perspective, that kind of venue provision shouldn't cut, as this legislator, I think, believes, always in favor of the industrial project. There was other legislation that really targeted environmental litigation. Of course, we only win lawsuits that are meritorious, but the constant talking point is that these lawsuits are frivolous and that we should take steps to cut back on those. Fortunately, our governor vetoed legislation last week that would have targeted broadly nonprofits that sue. But it's no joke that we have work to do to show support for these community efforts and remedies. And just to opine on an issue I haven't researched at all, as to the removal of local control over land use planning decisions. I think that presents a significant constitutional issue, similar to MIPA's unique role. It's only through local land use oversight that we have the ability for community members to participate in those important decisions about our future land uses, and the ability of local governments to actually do their job to prevent incompatible land uses, and the efforts to strip that control from municipalities, I think presents a constitutional issue similar to what the court looked at PCEC. But I'll turn it over to Michelle after that long-winded answer to talk about actual tools.
I think Jeff threw a fastball and you knocked it out of the park. So Jeff and I can talk about conflict mitigation more. I think that Jeff, did you feel like Jenny answered that question well? We've got some other ones here in the chat.
Yeah, keep going. I just wanted to get it out there for dialogue. And I think the whole point about, if this is constitutional, then the energies need to get focused on this legislation. Like, is it constitutional? And so it's got to be targeted at that, not on using that legislation for anything local.
Yeah, and I think the other big takeaway there that I hear from all of this and from Jenny's comments is that local power is really important. And when I think also what you brought up was, we learned the power of businesses organizing, and what is the next step for leaders in the Yellowstone Gateway Business Coalition. I know that Carrie has had conversations with folks, and that's kind of ongoing. But I think that we should all remember that there's a lot of power there, and that conservation groups really, like, as a voice, especially in this last legislative session, were not really deemed credible, and business leaders are, and in your opinions and your participation can change the outcome dramatically, and we saw that. And so I think that's, to me, an overarching message is just the power of people in our community representing themselves, landowners, business owners, citizens. We cannot do this without the power of community.
Yeah, you got it. Go ahead and move to the other questions. Thank you for the answer.
And Pete, you gave quite a good long list of questions here. I don't know if you want to unmute and ask them. Jenny, can you see the chat here? All right, there you are. Hi, Pete.
Sure. Yeah, listen, once again, congratulations to all of you on the hard work here and the terrific results. But I had questions about, all right, well, we read the Supreme Court decision and we see that outcome, but as a practical matter, what comes next? Is the Supreme, you see my questions. Are we all done in the Supreme Court? Is the litigation over? Secondly, what's going on now that DEQ is meant, under one portion of the relief, is meant to give us a do-over? What happens there? And third of all, maybe most important, what's Lucky Minerals up to? Are they going to lick their wounds and go on their way, or are they going to pursue this in some fashion that we can perceive so far in the way they've reacted?
Yeah, thanks, Pete, and thanks for your support throughout this issue. We are done in the Supreme Court. There was no motion for rehearing. The court sent it back to the district court, who confirmed, the vacatur, the invalidation of Lucky's exploration license. What that means for DEQ, as a general matter, this issue is on remand to DEQ. So DEQ still has a job to do to redo its environmental analysis. But I think as a practical matter, with my conversations with the DEQ attorney, it sounds like they're requiring the submission of a new plan of operations, a new permit application, in order for Lucky to proceed. It's not an agency that's in the business of just doing recreational environmental analysis. And it seems like Lucky is not heading down that road. It seems like they've given up on their pipe dream of mining next to Yellowstone. So I think that likely the Lucky saga is over.
That is good news. Thanks.
Can Pete, Jenny, can you guys all hear me?
Yeah.
Joe. So what we know, and Michelle might understand some of this too, because she gets some of the same alerts that I get, but Lucky Minerals is very focused on a project in Ecuador. So they're putting quite a bit of their energy and all their capital, as far as I can tell, into that project. And from what I know of the mining industry, and especially these small junior miners like Lucky, is even though they are not pursuing Immigrant Gulch at this time, it is highly unlikely that they'll just completely walk away. They'll most likely maintain their leases, maintain their land position, because that's really the bread and butter of those junior miners, is a secure land position. So the odds are that they'll just it'll just stay as is for the foreseeable future, until Lucky either goes away completely as a company. They may try to sell it to someone else, who knows, but I would expect the leases and the unpatented claims to remain in effect as is for the foreseeable future.
Well, in fact, isn't that the history of Emigrant Gulch for the last 150 years? I mean, every 10 or 15 years, somebody scrapes together a couple of bucks and buys up leases and mineral rights and takes another run at this.
Yeah, that's exactly it. I mean, in the 90s, the joke was it was two guys in a backhoe, that were up there digging around. But every time the next company makes them, it just gets that much harder every time another company comes around. They have more information. The commodity prices change, technology changes. There's a lot of uncertainty still in the gold mining industry in general. That's why it's such a difficult thing to fight sometimes, is that there's just so much gold fever out there, for lack of a better way of putting it.
Well, and isn't that the reason the Yellowstone Gateway Protection Act is so important to us? Because that's a permanent change that pushes the needle in our direction the next time somebody takes a run at this.
Yeah, Michelle and Jenny, if you want to say something about that, that's absolutely true. It's the best tool I can think of to have in our back pocket, but it doesn't solve every concern because of the private land interface and the nuances of the 72 mining law and very extralateral rights and a bunch of different things that are pretty wonky. But it's a great tool to have.
And
Again, thanks to all of you.
The withdrawal really changes the upside potential of any development of the private lands, as well, by constraining the ability to expand onto public lands. I think the cost benefit analysis that any miner would go through now is quite different than what Lucky went through when it initially made this proposal.
Hey, Jenny, congratulations, fantastic result. Do you know the extent to which this precedent has resulted in any equitable remedies and other environmental disputes to date?
Yeah, I know of a few where it's at issue. One is an issue that actually was already resolved by the Montana Supreme Court, where the court found that the constitutional provisions at issue did not affect that case. That was a case involving the dewatering of wilderness streams for a mining project in Northwest Montana. And the way the court distinguished that case from this case is it said there there were other remedies available. There were other things that the plaintiffs could do to prevent the environmental harm that was at issue through the operation of the Montana Water Quality Act. Whereas in our case, it was really focused on MEPA, and MEPA was, the centerpiece of our effort to avoid that environmental harm. And so that's a really, it's an unfortunate narrowing of the precedent, but it's a something that's important for advocates to understand going forward in the legal analysis, that statutes like MEPA that really have this unique role in our protective environmental regulatory scheme are the ones where these constitutional protections are really focused. And I think, going back to the local land use control, I think that that's a similar issue there, where you have a state regulatory vacuum over competing land uses. That's really an issue that is traditionally relegated to, local officials to consider. So I think, being able to frame those issues in the terms that the Supreme Court framed them in this subsequent case is important. And then, I think Wendy asked this question in the chat, and it relates to yours, Joe, about where, what the status of MEPA is now, whether, Wendy asked, does it revert to how it was before the 2011 amendment? This is a strange thing about this, the statutory amendment, is that the legislature probably knew it was unconstitutional, and they said in the enacting language, if a court finds this is unconstitutional for some reason, these substitute provisions kick in. And what those substitute provisions do is they really target injunctions. So not the type of remedy that we got here, but where you're seeking preliminary injunctive relief. The provisions that are now operative in MEPA require you to make kind of a heightened showing, demonstration of evidence to get that kind of injunctive relief. So it's not exactly as it was, but it's better than it would be.
Jenny, I saw Luis was raising his hand, so I'm hoping we have time for one more question. I do want to stop at one. So Luis, if you want to unmute, you can ask your question. And then my other request, Joe Josephson, I know you guys are doing a program on mining in the GYE. If you want to dump information for that in the chat, I think that might be something that folks on this call would be interested in participating in and learning more about as well. Go ahead, Luis.
Yeah, I was just kind of going to add a little bit more as to what Joe was saying earlier. He was mentioning the Frontera project over in Ecuador, and I was on Lucky's website not too long ago, and those two projects are still listed up there. So it's the main focus that they have going on right now. So Joe already went into this a little bit more before I could get my 2 cents in. I was just going to mention that it doesn't seem like it's going to be going away in the history of these projects and the way that these mining corporations hold on to the permits that they have. It goes a long way. So I foresee it happening and then revisiting this project again in the future. So that's all I was going to say.
Thank you. Yeah, those Google alerts I put in the chat there too. You can sign up for, I think I get alerts for Emigrant, mining, Lucky Minerals, and it's a good way that stuff will pop into your email as Lucky Minerals hits the news. It's a good way to quickly pay attention to what they're doing. Joe, do you want to share about your meeting quick in this last minute here? Invite folks to.
Thanks for that. I appreciate that. I'm madly looking for the link in my little screen. I'm having too many windows open, so I'm trying to find it. But on the 25th, next Tuesday, that is, at 4 p.m., we'll be hosting a webinar where I'll be joined by my colleague, Allison, who's on this call here, Allison from our Idaho office, Allison Mikulski. And we'll be talking about just sort of mining in general. So we won't get into the same kind of detail that you guys in the weeds of any particular project, but Allison is working on a gold mining project on the Centennials, in the Upper Snake River called Kilgore by another Canadian mining company. So, and they've had some successes in the Idaho courts as well. And we'll just be talking about that project, as well as some of the work that GYC's done over the years, including their work around the Yellowstone Gateway and some of the stuff over by Cook City as well, and just kind of our history with hard rock mining around Yellowstone. So yeah, I would welcome everyone. I think Allison's going to post the link. I think she was able to find it a little more quickly than I. So yeah, I appreciate the shout out, and hope to see some of you then.
It's in the chat. So thank you, Allison. Thank you, Joe. Thank you, Jenny, Carrie, to all of our participants. Stay tuned for more on conflict mitigation as an important tool to help us regulate what's happening on private property. We'll have more conversations about that in the future. Carrie and I are always happy to answer questions one-on-one. We look forward to seeing you at the next conversation. Take care.